Good afternoon. It's Tuesday, October 5th, and welcome to another edition of Level Up Law with South Carolina Legal Services. My name is Stephanie Vanderhorst. I'm the Employment Law Unit Head for South Carolina Legal Services, and today we'll be talking about vaccine mandates. Specifically, we'll be talking about employers mandating that their employees receive the COVID-19 vaccine and whether or not that's legal in the employee and employer relationship. Thanks for joining me, and I hope you find our session today informative. Before we get into vaccine mandates, it's important to understand employee and employer relationships in South Carolina. South Carolina is what's called an at-will employment state. That means that employment relationships that do not have written contracts setting forth the terms of the employment relationship are governed by the doctrine of at-will employment. The doctrine of at-will employment states that either the employee or the employer can terminate the employment relationship at any time without consequence. That employment relationship can be terminated for any reason at all or no reason at all. There are still limitations on the reasons that employers can terminate employees in an at-will employment state. Employers are still prohibited for terminating employees for discriminatory reasons. That means that an employer may not terminate an employee because of the employee's race, sex, gender, religion, national origin, disability, or age. One of the most recent cases addressing that question comes out of a case in Kentucky. 47 employees of St. Elizabeth Healthcare requested that a federal court issue a preliminary injunction against the enforcement of the company's COVID-19 vaccine mandate. The company's vaccine mandate required that all employees either get vaccinated or provide a valid medical or religious exemption. U.S. District Court Judge David Bunning ruled that St. Elizabeth's vaccine mandate was legal and refused to enter a preliminary injunction barring the enforcement of the mandate. Employees of St. Elizabeth Medical Center were required to be vaccinated by October 1st of this year. In his ruling, he stated, if an employee believes his or her individual liberties are more important than the legally permissible conditions on his or her employment, that employee can and should choose to exercise another individual liberty, no less significant, the right to seek other employment. He went on to say that actual liberty for all of us cannot exist when individual liberties override potential injury done to others. This is not the only case supporting an employer's right to impose vaccine mandates. There have been cases out of Texas, also cases out of New York, that basically say the same thing. And in addition to the most recent litigation in this area, there is precedent that is over 100 years old for vaccine mandates. The first case to address this question was Jacobson v. Massachusetts. In that case, a Massachusetts law allowed cities to require residents to be vaccinated against smallpox. Now, during an epidemic in Cambridge adopted an ordinance requiring vaccinations. The failure to comply with the smallpox vaccination resulted in a $5 fine. Now, a local pastor named Jacobson refused to comply with the vaccination requirement and was fined $5. He fought the $5 fine and stated that the fine and the mandatory vaccination requirement violated his 14th Amendment right to liberty. The Supreme Court disagreed with him and found that the liberty secured by the Constitution of the United States to every person within its jurisdiction does not impart an absolute right in each person to be at all times and in all circumstances wholly freed from restraint. The court found that the law was a legitimate exercise of the state's police power to protect the public health and safety of its citizens, and that the smallpox epidemic posed a significant and valid threat to public health, making the requirement of the vaccine neither unreasonable nor arbitrary. The Jacobson decision involved a vaccine mandate implemented by a local government. In the cases that are being decided today, we are talking about private employers and not local governments. What does that mean? That means that it's going to be a lot easier for a private employer to implement a legally enforceable vaccine mandate in its workplace. Generally, the Constitution of the United States protects individuals from intrusion by the government and not by other private individuals or employers. Based on this decision in Jacobson and the 100 years of law that followed, the Equal Employment Opportunity Commission issued guidance on vaccine mandates in May of 2021. And basically, this is what it says. They say federal law permits vaccine mandates. Employers must be vigilant for disparate impacts that their vaccine mandates may cause. And employers can ask about vaccination status and require proof of vaccination. Now they expand on this guidance. So when they say that federal law permits vaccine mandates, they're saying that equal employment opportunity laws do not prohibit an employer from mandating the COVID-19 vaccine for all employees entering the workspace, subject to the reasonable accommodation provisions of the ADA and Title VII. Now, when it talks about the reasonable accommodation provisions of the ADA and Title VII, it's talking about those mandates being discriminatory, meaning if someone is unable to get the vaccine because of a disability and the employer fires them, that might be considered discrimination and wrongful termination in the context of employment law. So we need to keep that in mind. Now, additionally, employers must consider how their vaccine requirements may disparately impact, certain employees based on protected characteristics. So if a certain group of employees is unable to get vaccinated and they have a protected characteristic, such as a disability, then even though the vaccine mandate by the employer is not in and of itself discriminatory, it has that same effect on those individuals that have the disability. Now, another hot button issue is what employers can ask about your private medical history. And basically the EEOC says employers may require written documentation and confirmation that an employee received the vaccine. It's not illegal for them to request those documents and that proof. However, the employer is responsible for ensuring that the information is kept confidential in an employee's confidential medical file. So what does all this mean? What do the cases mean? What does the EEOC's guidance mean? Basically, it means if an employee refuses to comply with an employer's requirement to be vaccinated against COVID-19, an employer has the right to terminate that employee. And currently, we're seeing employers start to implement those hard deadlines and terminate employees for their failure to get vaccinated. In general, employers have an obligation under the Occupational Safety and Health Act, OSHA, to ensure they provide a safe and healthy work environment for their workers. And as part of that, the employer may require that all employees obtain vaccinations as part of a legitimate health and safety requirements. Vaccine mandates are considered reasonable and necessary in many industries, including the healthcare industry and sometimes with childcare workers. In the midst of a global pandemic, the reasonableness will expand to include other industries as well. Now, is this a blanket right for employers to require the vaccine or terminate an employee? No, there are exceptions. Those exceptions relate to Title VII and the Americans with Disability Act. Title VII of the Civil Rights Act provides that employees shall be free of discrimination on the basis of religion. Employers are required to accommodate an employee's sincerely held religious beliefs unless doing so imposes an undue hardship on the business. Now, employers are permitted under Title VII to inquire into whether an employee's religious belief is in fact legitimate. That means that the employer can ask about the employee's vaccine history and even church attendance. Now, religion is defined very broadly under the law and not only encompasses organized religion, but also informal beliefs. For example, there's a case called Genzira v. Cincinnati Children's Hospital Medical Center, in which the court recognized that veganism may constitute a sincerely held religious belief, and that belief exempted an employee from a flu shot requirement. Flu shots include an animal byproduct as an ingredient. It's usually some sort of egg byproduct. And of course, vegans do not consume animals or animal byproducts. So that's how the court got to that decision. Now, other religions may object to vaccines. Now, it's worth noting that there are no major religions in the United States that have come out against the COVID-19 vaccine. However, it's also worth noting that the leader of your religion does not necessarily need to do that. Religion is very personal. The court recognizes that. It also recognizes that your personal beliefs may not exactly mirror those of the religion as an organization, as a whole. So, anyway, now, even though a sincerely held religious belief could be a valid exception to a vaccine mandate, it's worth noting that employers have the right under the law to determine the accommodation and do not have to provide the accommodation requested by the employee. And Additionally, an undue hardship is a very, very easy burden to meet on the part of the employer. It is defined as more than a minimal cost or burden on the employer's business. So, uh, really, any significant cost the employer is sufficient to deny the accommodation. The other broadly recognized possible exception to a employer-instituted vaccine mandate would be a medical exception. So, under the Americans with Disabilities Act, employers may not require a vaccine for an employee whose disability prevents the employee from becoming vaccinated unless the employer is able to establish a direct threat, which is a significant risk of substantial harm that cannot be eliminated by a reasonable accommodation. Now, medical exemptions fall under a lot of different categories. The most, I guess, prevalent ones, I would say, would be allergies to vaccine components. So if the employee has a history of anaphylaxis or allergies to other vaccines, that could be a valid medical reason not to get the vaccine. Additionally, certain vaccines cause what's called Guillain-Barré syndrome and can cause paralysis for an individual. If there is a history of that in your family, that could be another possible valid exception to getting the vaccine that your employer is mandating. And in other cases, you may have some sort of medical condition that makes it unsafe for you to be vaccinated at that time. Now, you would need to provide proof of those medical issues to your employer, the issues that make the vaccine risky for you, and then the employer can decide or needs to consider whether it can provide an accommodation. Now, that reasonable accommodation has to eliminate the threat that you pose by being unvaccinated. Now, in determining whether an unvaccinated employee is a direct threat, uh, the employer has to consider several factors like the work environment, the ventilation in the area. Are you working inside? Are you working outside? How much interaction and contact do you have with coworkers? How much interaction and contact do you have with the public? How many other employees are vaccinated or partially vaccinated in the workplace? And are those employees wearing masks? Are they being tested? Things like that. Now, like the religious exemption, an employer is not required to provide an accommodation if doing so would cause an undue hardship to the employer. However, an undue hardship in the context of a medical exemption is a lot harder to prove than it is in the context of a religious exemption. Now, an undue hardship under the ADA means that the accommodation would be unduly costly, extensive, substantial, or disruptive, or would fundamentally alter the nature or operation of the business. So what does this mean? I mean, basically this means if the accommodation is something like you're required to wear an N95 mask at work at all times, or I don't know, maybe a PAPR if you're in a healthcare facility, uh, then, you know, it would be hard for the employer to make that argument that it was unduly costly or extensive or substantial or disruptive or would fundamentally alter the nature of the operation. Additionally, when it comes to costs, employers cannot just decide that the cost of the accommodation is too much for them. They have to consider other less costly accommodations. They have to consider whether there's funding available from an outside source, like a vocational rehab program, to pay for that accommodation. And they have to provide the employee with a disability the opportunity to provide the accommodation or pay for the part of the accommodation that poses the undue hardship or that is too costly. So it is a lot. The undue hardship argument under the ADA is a lot harder to make for an employer because there are so many factors and other considerations that the employer has to make in order to deny that accommodation. Now, we've talked about the exemptions. Let's talk about what types of reasonable accommodations have been found to be legal and what types of reasonable accommodations the EEOC has suggested would be acceptable. So those include wear a face mask, socially distancing the unvaccinated employee from other coworkers and non-employees, providing the ability for the unvaccinated employee to telework, to work off-site, out of the main building and away from other employees, possibly customers. And probably the most unpopular accommodation also includes unpaid leave. So in several cases, employers have decided that in the context of the religious exemption, the reasonable accommodation that they can provide is to provide unpaid leave to those employees that refuse to get vaccinated. This is happening in several states in the US. It has also been upheld legally in prior cases regarding reasonable accommodations. So we have examined Atwill Employment. We've examined existing case law related to vaccine mandates starting in 1905 and going to up until 2021. And so let's ask the question, can my employer mandate the COVID-19 vaccine? And the answer is yes. It looks like employers have the right to mandate the COVID-19 vaccine. Like I said previously, employers have the right to set the terms of the employment contract. That includes the right to require its employees to be vaccinated against a public health threat, such as COVID-19. Now, if you or an employee provides a valid medical reason for not being able to get the vaccine, then that employer has to, at the very least, contemplate a reasonable accommodation for that employee. If an employee submits that they should be exempt from the vaccine mandate due to closely held religious beliefs, the employer has to provide that reasonable accommodation unless it causes an undue hardship. And of course, in the context of Religious exemptions, undue hardship is a very easy bar for the employer to meet. And in that context, a reasonable accommodation can be unpaid leave. So maybe not termination, but certainly the employer can put you on leave for the foreseeable future. That concludes this installment of Level Up Law. Thank you for joining us this Tuesday, October 5th. We'll be back next week with another episode. Until then, if you have any issues or need assistance, please contact us at the information provided here. Again, thank you very much and have a great week.